me in the bike lane.
You have 2 seconds to give me some ID or give me your name.
I don't think I have. What's your reason why?
I told you. Put your hands behind your back. I love people like you who think that you're going to tell me the law. You think that you're Mr. Law Johnny Awesome and you know everything. So walk over to this officer's car and give him all your information, or you're going to get another charge for resisting obstructing.
If you'd like to see the full police encounter, head over to our companion episode on Audit the Audit, linked in the description and in the pinned comment. Now, after the body camera footage was played, Sergeant Terracinno's testimony continued through additional direct and cross-examination. The city and the defense were then both permitted to make closing arguments.
We'll move on to closing arguments. Attorney Horn. Let's make sure Mr. Pletz is still with us, just because I'm not getting video or audio. There we go. Okay. Attorney Horn.
Thank you, Your Honor. The people have shown that Mr. Pletz was riding in the middle of the roadway, whether it was narrower or not.
A Detroit police officer spoke into his body camera at 2:32 in the morning. He said 5 words that later became part of a judge's official ruling. Do you want to argue with me? This officer had 27 years of experience, and that question was his whole legal argument. Not a law, not a rule from the book, just a question meant to shut down the conversation. It didn't work. 2 months later, a judge looked at this same video. She ruled that the officer, not the cyclist, was the one who didn't understand the law. Picture one bicycle tire. It's squeezing through a tiny gap between 2 orange construction barrels. That gap is the whole case. Everything the city argued, every ticket written, every claim of resisting and obstructing. It all comes down to one question. Did a man named David Pletz have the legal right to leave a blocked bike lane and ride in the open road instead? 1 tire width of space. That's what this entire court case was built on. Before we go further into what the court records actually say, make sure you're subscribed to Police Misconduct Case, because we don't just tell you the headline. We follow the law all the way to the final decision. Here is the official story.
2026, defendant David Pletz was charged in the 36th District Court in Detroit, Michigan with disobeying a lawful order of a police officer and interfering with traffic. The charges arose from an encounter with Sergeant Brian Terracinno of the Detroit Police Department that occurred at around 2:30 a.m. on March 4th. Mr. Pletz entered pleas of not guilty, and the matter proceeded to a bench trial on May 21st, 2026 before Judge Malaika Ramsey Heath. The trial was held via Zoom, with the city being represented by Assistant Corporation Counsel Tamika Horn and Mr. Pletz being represented by defense attorney Darnell Barton. Altogether, this trial lasted nearly 2 hours, so we will only be covering excerpts in this episode, and the full trial is linked in the description below.
This is City versus David Pletz. We have 1 count of disobeying a lawful order of a police officer and 1 count of interfering with pedestrian traffic. We're set for trial today. Officer is here. Mr. Pletz is here. As a preliminary matter, as I open the file, there is a motion in this file to suppress, which appears to have been filed back on April the 14th. What's the status of that, please, Attorney Barton? This is Mr. Pletz's motion.
Yes, Your Honor, if I may, I wasn't assigned when that motion was filed, so I'm unable to speak on behalf of that particular motion, but we will address the issues within that motion today, Your Honor, which deal with the suppression component. So
thank you. Okay.
On March 4th, 2026, at 2:32 in the morning, Sergeant Brian Terracinno of the Detroit Police was on patrol. He saw a cyclist riding in the middle of the road instead of in the bike lane next to it. Based on just that, he gave the cyclist 2 charges: disobeying a police officer's order and blocking traffic. 27 years on the job. Special training on bicycle laws, and his opening statement to the court was simple. Cyclists must use the bike lane. No mention of any exceptions.
Why, if the obstruction that Mr. Pletz encountered triggered one of those exceptions?
All right. Attorney Horn, who's your first witness?
That would be Sergeant Terracinno.
Thank you. Sergeant Terracinno, please raise your right hand and swear affirm that everything you tell the court today will be the truth.
I do.
Thank you. Attorney Horn?
Yes, thank you, Your Honor. Sergeant, where are you currently employed?
The City of Detroit Police Department, 4th Precinct.
And how long have you been a police officer?
27 years, ma'am.
And during that 27 years, have you had any training as it relates to traffic
Yes, ma'am.
and specifically to bicyclists?
Yes, ma'am.
Okay, and for purposes of what the subject matter of in this case is, what in particular have you learned in your training as to bicyclists?
Briefly, when there are bike lanes available, citizens are to use those bike lanes. More importantly, in this incident, the individual, the defendant, was riding his bicycle in the middle of vehicular traffic lane with a bicycle lane provided.
Okay, and we will get into the depth of the conduct that created the issuance of these tickets.
Yes.
Are bicyclists held to the same standard as motor vehicles?
Yes, they are. They have to operate their bicycle in a safe manner as anyone would be driving a vehicle.
Thank you. And on March 4th, 2026, were you on duty?
Yes.
But Michigan law does have exceptions, several of them. And that is where this official story starts falling apart. Under Michigan law, Section 257.660A, a cyclist riding slower than traffic must stay close to the right side of the road. But the law also lists clear exceptions: passing someone, turning left, avoiding danger, riding on a one-way street. Avoiding danger is written directly into the law. Not avoiding danger unless the officer disagrees. It's simply there, written by the same lawmakers who wrote the general rule. And in 2006, Michigan lawmakers went even further.
Yes, ma'am.
At approximately 2:32 a.m.?
That is correct.
And would that been in the area of Green Street and West Fort?
That is correct.
And is that the city of Detroit?
Yes, ma'am.
What brought you to the area, Sergeant?
I was on routine patrol traveling westbound on Fort Street at that time.
And what did you observe at that time?
At that time, I just observed the defendant riding a bicycle in the middle of the only lane available for vehicular traffic, while bicycle lane was provided.
You say a bicycle lane was provided, and he was in the middle of the road, as you stated, correct?
Correct.
Were there any other vehicles around at that time?
I don't recall. There were no vehicles in front of us. I believe one or two vehicles may have passed going eastbound, but I can't recall.
Okay. And does an actual obstruction or blockage or interference with traffic have to happen in order for you to issue a blockading ticket?
No, the actual blockading was the defendant riding in the middle of the traffic lane, which even if he was authorized to ride in that lane, he would have to move over to the farthest right side of the road for vehicular traffic, which he did not.
On direct examination, Sergeant Terracinno testifies that an actual blockage of traffic did not need to occur for the interfering with traffic offense to be established, taking the position that Mr. Pletz riding in the center of the lane when a bike lane was provided constituted the interference itself. Section 257.676B of the Michigan compiled laws, the statute underlying the interfering with traffic charge against Mr. Pletz, prohibits blocking, obstructing, impeding, or otherwise interfering with the normal flow of vehicular, streetcar, or pedestrian traffic on a public street or highway. However, in the 2022 case of People v. Luzinski, the Michigan Supreme Court held that this statute is violated only where the normal flow of traffic is actually disrupted, and that potential interference with hypothetical or non-existent traffic is insufficient, reasoning that any other interpretation would render every person crossing a street potentially.
They removed an older rule that used to allow cities to force cyclists into bike lanes no matter what. Lawmakers chose to take that power away. So when the officer told Pletz that using the bike lane was mandatory, he wasn't just wrong about this one night. He was repeating a rule that Michigan had already deleted from its law books 20 years earlier. An order is not a law. Remember that phrase, because it's going to matter 2 more times before this case is over. Here's the actual scene the court eventually had to look at. Fort Street, that night, wasn't a clear, open bike lane. It was full of construction, barrels, detour signs, sandbags, narrow lanes. The defense argued, and the video seemed to support it, that Pletz hit an obstruction inside the bike lane. And Michigan law, section 257.657, says a cyclist in that situation has the same rights as a car. meaning he's legally allowed to move into the open lane to safely go around the obstacle. When the officer was questioned in court, he could not clearly say whether the road had actually been narrowed by construction that night. 30 minutes of questioning, one simple yes or no question about construction cones, and the officer, under oath, still couldn't give a straight answer. Now here's the exact moment from the body camera, taken word for word from the public court record. Pletz tells the officer there's a sign up ahead saying the bike lane is closed. The officer doesn't believe him, so they ride back together to check. They find a sign. It's a construction sign sitting right in the bike lane.
He's the gentleman with the beard, Mr. Pletz.
Okay, and you recognize that as the person that you interacted with during this incident?
Yes, ma'am.
Okay. Your Honor, may the record reflect that the sergeant has identified the defendant?
The record will so reflect.
And once you ran into the defendant, what did you do?
When I first observed the defendant riding in the roadway, I grabbed the bullhorn, the microphone on my vehicle, and I gave him a warning and asked him to move into the bike lane.
And did he do that?
He did not.
And what followed after that?
I gave him a second verbal warning with the microphone of the vehicle, to which the defendant responded by taking his hands off of the handlebars of the bicycle and started operating the bicycle without his hands down the middle of the roadway.
And he continued down the middle of the roadway?
Correct.
Okay, and at that point, even after those two commands, did he proceed to get on the bicycle lane?
No, he did not.
Okay. And then what else happened?
At that point, there was a break in the construction cones. I was able to pull up alongside of Mr. Pletz, roll down the window of my vehicle, and I asked him if he heard me via the microphone and asked him if he heard me asking him to get into the bicycle lane.
And what was his response to you?
His response to me was that there was a sign a little bit east of us that said that the bicycle lane was closed. And I said, I'm not aware of any sign back there that says the bike lane is closed. I said, would you show me? And we proceeded to go back east on the roadway where we first passed. And there was a sign in the bicycle lane, but that was just a construction sign. And then I proceeded to tell him that the bike lane was not closed and that he needs to operate his bicycle in the bike lane where it is provided.
And at this time, were you wearing body-worn camera?
Yes, ma'am.
Your Honor, the people would request permission to publish the body-worn cam. First, I want to lay the foundation of whose camera this is.
Madam Prosecutor, we would stipulate to any videos.
Okay, thank you.
And plays Sergeant Terracinno's body camera footage for the court.
Oh, wait a minute. You're telling me that you can't slow your... No, that's detour for street traffic. Do you want me to take your information and do you want to argue with me? All I told you was to ride in the bike lane. Do I want a lawsuit?
Yes.
Let me see your ID.
I don't have it on me.
Oh, what's your name?
I don't think I have to do it.
Well, yeah, you do.
I broke the law.
I'm telling you. Well, I don't care what you think. I'm telling you. Do you have a headlight on your bike?
Yes, I have a headlight.
Yeah, well, why isn't it on?
It doesn't have to be. It's a bicycle.
Well, you're the one who said that you can't avoid obstacles. And if you have a headlight, maybe you should have it on to not hit obstacles. Does that make sense to you?
Maybe the obstacles shouldn't be in the bike lane.
You have 2 seconds to give me some ID or give me your name.
I don't think I have. What's your reason why?
I told you. Put your hands behind your back. I love people like you who think that you're going to tell me the law. You think that you're Mr. Law Johnny Awesome and you know everything. Now walk over to this officer's car and give him all your information, or you're going to get another charge for resisting obstructing.
If you'd like.
The obstruction Pletz talked about was really there, and the officer confirmed it himself by going back to look. But after confirming it with his own eyes, the officer didn't rethink the stop. He escalated it instead. You have 2 seconds to give me some ID or give me your name. Then came a threat of an extra charge.
Terracinno's testimony continued through additional direct and cross-examination. The city and the defense were then both permitted to make closing arguments.
We'll move on to closing arguments. Attorney Horn. Let's make sure Mr. Pletz is still with us just because I'm not getting video or audio. There we go. Okay. Attorney Horn.
Thank you, Your Honor. The people have shown that Mr. Pletz was riding in the middle of the roadway, whether it was narrower or not. He even admitted himself in the video that he should be to the farthest right. Sergeant Terracinno also testified that if the bike way was not available, that he should be to the far right. Mr. Pletz's and his bike, as he was riding, were in the middle of the roadway and blocked the officer. The officer is also a citizen with rights, motor vehicle rights, and a bike should not have been there, whether it was narrower or not. There was mentioned to be an obstruction that he had gotten past already, and Mr. Pletz was not complaining that there was an obstruction. He actually thought the bike lane was closed, and he may have hopped off the pathway. We don't know if that's where he started. When Sergeant asked him to get on the bike lane and use that bike lane 3 times, he refused to do so, and as a matter of fact, commenced to arguing with the officer. Officer testified that he was not even seeking to give a ticket, and I can understand why. We're talking about 2:32 a.m. in the morning. That argument ensued, and the interaction ensued at the instance of Mr. Pletz. There's some video that is missing, and that happens. But for centuries, we've used the testimony of the witnesses to flesh out cases. The question here, outside of any red herrings that I found personally or professionally, was number one, was a lawful order made? Yes, it was. The statute provides 257-602 of the Michigan legislature states a person shall not refuse to comply with a lawful order or direction of a police officer when that officer, for public interest and safety, is guiding, directing, controlling, or regulating traffic on the highways of this state. West 4th Street is a public roadway in the city of Detroit, and that's where Sergeant was on duty, and he was directing traffic. While he may have been the only vehicle that was blocked, he was in fact blocked while he approached Mr. Pletz's bike. In addition to the lawfulness of the order, it came from him regulating traffic. As far as interference with normal flow, Sergeant testified that he was interfering with his own flow. And so that is impeding just by nature of a pedestrian or even a vehicle blocking traffic, being in the middle of the roadway. And he still could have been to the far right, no matter how narrow the roadway was. Outside of that, these are the issues that are here. As far as the obstruction, I think that's something that was thrown into the picture because I don't think in the video, nor was it stated here, until it formed into an obstruction. I think the issue was that he believed that the roadway was closed, the bike lane was closed. He didn't complain about any obstructions on the scene. He didn't complain about not being able to get through somewhere. And at that point, he had already got past that. So if he'd already gotten past that, why are we using it as an obstruction now? All the officer did was say, hey, please hop on the bike lane. And like I said, if that's where he started, I believe that people have proven the burden beyond a reasonable doubt and by the preponderance of the evidence that he had impeded traffic. Thank you, Your Honor.
Resisting and obstructing, added on top of a stop that had just been proven wrong by the officer's own investigation. Think about what really happened in those 60 seconds. A man, alone, on a bicycle, at 2:30 in the morning, pointed to a real physical obstruction that truly existed, and watched an armed government official decide that being right about the obstruction didn't matter. Because the real crime in the officer's mind was refusing to just be told what to do. Was this a normal traffic stop? Or is this what happens when being correct becomes the actual problem? That is the question this case forces us to ask. Because the official court record answers it in words most police departments would never want made public. The traffic blocking charge also falls apart once you look at the actual law. Michigan Statute 257.676B says traffic must be actually disrupted, not possibly disrupted, not maybe disrupted. In 2022, the Michigan Supreme Court ruled on this exact question in a case called People v. Luzinski. The court said that blocking traffic that isn't even there doesn't count as a crime. There has to be real vehicles really blocked. At 2:32 a.m. on Fort Street, court records show there were no cars ahead of the police car, and at most 1 or 2 cars passed the whole time. The judge herself pointed out something the prosecutor never explained. In that same video, a large oil tanker truck drove right past several parked police cars and officers standing in the road with no problem at all. If a truck and multiple police vehicles could pass through just fine, the claim that one bicycle blocked traffic simply doesn't hold up.
Point in time, we just want to make the very clear arguments as it relates to the two components that the court, the bike lane and the ID. We'll get to the third component, which is credibility, after. So the bike lane itself, Your Honor, we've already concluded that there was an obstruction. How and to what degree down the road there were further obstructions, my client would not know. Once he approached no obstruction, he would have to do what any other logical driver would do, which is to be in a safe distance, which is where he placed himself, a safe distance from that obstacle. And we saw the distance, we looked at it on the camera, it was about yay big. So in order for his bike to go through that distance, literally his pedals would be on both sides of that little pier, meaning that only the tire would be able to get through. So as it relates to safety, the MCL says that a biker has, as a motorist as well, just not a biker, but a motorist has the right to a safe passage, and it has to be reasonable. So again, when the officer says, hey, the guy told me that there was a sign that said this road was closed, and we go back there and we see it wasn't closed, he's missing the reasonable component of it. It was blocked. It was still obstructed. So instead of him taking that time to, as he said, he's an officer of 30 years and taking that time to de-escalate, he re-escalated. And then he continued to berate this man, calling him a clown, a beach hippie, alleging fraud. It was pretty egregious. However, they said that it was 2 a.m. and there's no cars on the road. That was the point, because there was no interference in traffic. And if the officer is saying he was interfered with in traffic, then the officer should know that, again, because he loves people who knows the law, he should know the law, that he has to give the bicyclist 3 feet of space as per the Michigan Vehicle Code Act 300 of 1949. It's 257636, overtaking and passing vehicles. So the officer should have known that had he known the law, that he was in the wrong if he thinks he was the vehicle that was not giving safe passage. Second, Your Honor, we asked about the video, not because we don't believe that not having the video should allow for a dismissal. What we're saying is if the young man was in the road, you're saying that you had your body cam on, there's a scout car, and not one video of this occurring? The only video you have is after you and him are arguing, which insinuates, going back to the third component of credibility, that there's a lack of credibility in this particular officer's statement. And we know that for a fact, based on the fact that it took him 30 minutes to answer yes or no questions. Let's move on. The next thing is the ID. So as far as the bike lane is concerned, we have already gotten him to admit that there was an obstruction. He's already ruled that 257660A says that the cyclist has the right to travel, and if there is an unsafe or unreasonably safe road, then they can maneuver around it, right? So we know that for sure. And we also know MCL 257657 says that bicyclists on the road are operating as if they had the same duties as a driver, right? Now, the ID, they're saying that he had a lawful order. Well, we've already established that the order wasn't lawful because the young man had the right to not be in that bike lane due to the obstruction. We know that it was an obstruction, he agreed, and we also know that they didn't even go forward to try and remove the obstruction afterwards. So I'm assuming somebody else is probably dealing with that same situation. However, if there was no lawful order, then there was no lawful requirement for him to give an ID. And I even asked it, although there was an option to object to speculation, he still answered it. It was a logical question. If he was riding lawfully, would he have to provide ID? No, that was his answer. And that's the law. That's true. So now we know he was lawfully able to avoid that bike lane. For what distance? We don't know, because we don't know to what degree the obstruction could have occurred down the road. The officer says he didn't see any obstruction. And then the young man brought him to the obstruction. And now he's saying, okay, well, yeah, but it's only here. Well, how does he know that? How does he know what distance this young man was traveling before he got to where the officer was for him to say there's no other obstructions? Maybe this young man ran across several obstructions down that road, and he just used logic that said, hey, it's 2 in the morning. I'm going to run into one of these obstructions. Let me move over. There are no cars in the road. Last thing, again, I'm going to, Your Honor, is to the credibility. And again, I say this with all due respect. I work with officers all the time. I work with ceasefire. I'm a former state prosecutor myself. What I'm saying is that as it relates to the credibility of this particular officer, it was very clear that my client violated the number one rule, which was pissing off an officer. That's it. That's all he did. He made this guy upset, and he did not want to take it from, he didn't want to de-escalate from there because he thought he was doing him a favor. He thought he was just gonna, hey man, I'm just telling you get out the road, I'm helping you out, etc., etc. But no, he wasn't helping him out. When the guy gave him pushback, when my client gave him pushback and told him the actual law, then he started to berate him on internet law and all that. So again, Your Honor, I just want to make sure that we're clear. MCL 2567 says he can operate as a vehicle. MCL 2567660A says that a cyclist riding slower than traffic generally must ride aside as close to the edge as practical, the right-handed curb, or edge of the roadway, except when conditions make the right edge unsafe or unreasonable to use. That's why I asked the officer, and it took us 30 minutes to get a yes or no question that we can see on the video. Was there construction narrowing the road? In any way, was the road no longer the way it was intended as it was designed, and the construction cones changed or altered that? Very simple question, and yet the credibility of the officer allowed him to be evasive to that. Why? Because he knows MCL 257660A says if that was narrowed, that changes the dynamic of where he is to go, to the right or left, because it's not safe. So with that said, Your Honor, we would respectfully ask that they dismiss these charges, both of the charges, because one leads to the other. One was that he disobeyed a lawful order. There was no lawful order. Second off, that he failed to present ID, which is, again, improper because he was not required to present ID. With those stated, Your Honor, we would respectfully ask that the court dismiss all of the relevant charges. Thank you.
All right, thank you.
Rebuttal, Your Honor.
And then there's the missing video. The defense pointed out, without any pushback from the city, that even though the dash camera and body camera were both running, the footage doesn't start until after the argument has already begun. Not the first contact, not the loudspeaker warnings, just the argument already happening. In a case that depends entirely on what happened in the moments before the camera started recording, that missing footage isn't a small detail. It's everything. Because it's not the defendant's job to explain missing government evidence. That responsibility stays exactly where the law puts it, on the prosecution.
All right, I'll allow rebuttal.
Okay. Thank you, Your Honor. In this particular case, there was a lawful order given, and it was simply to please get back on the bike lane. And if not, if you're riding near the curb or close to the curb, farthest right of the traffic, it was talked about here that that would have likely been okay. But in this case, he was riding in the middle, in the front of the officer's vehicle, in the very front. And so while he decided to jump, we don't even know where he started. We don't even know if he started on the bike lane. But his reasons.
Stop. This is closing. Ms. Horn is speaking. Stop.
Objecting to facts not in the record, Your Honor. There was no
right, and we don't even know where he started. So as far as being in the roadway, this is what the officer testified to. He was in the middle of the roadway. He was not in the bike lane, but some of the argument is that he was not in the bike lane for some justification. However, He was no safer in the middle of the street at 2:30 in the morning, and officer was not trying to pass him. So as far as being safe passage and enough room, the officer was not trying to pass him. The officer was giving a lawful order to use the bike lane instead of the middle of the road. He got a lawful order from the police, and he repeatedly refused to identify himself. While the defense may feel that it was not lawful for him to pull him over because he was doing everything right, even if he wasn't, he has a justification for doing what he did. When a police officer asks you to identify yourself, that is a lawful order for investigation purposes only, and he was merely detained. Thank you, Your Honor.
Thank you. All right, we'll take these one at a time. First, let's deal with the interference with traffic. What the law says, and part of the issue is that we're dealing with subjective judgment all around here, from the cyclist to the officer to those of us who are viewing the video. And that's because the law is framed subjectively in this kind of a case. What it says is that they are to ride as close as practicable, right? Practicable. There goes the first subjectivity. What's practicable to you may not be what's practicable to me. They are to ride as close as practicable to the right-hand curb or edge of the roadway. Here's second part, is all of us who've been to law school know about elements. When traveling slower than surrounding traffic. That's the second element. Was he as far right as practicable? Was he traveling slower than other traffic? Then there are the exceptions. Overtaking, making a left turn. Here's the big one for us today, avoiding hazards and one-way streets. Those things allow the cyclist to leave the right curve in terms of practicability. I have the great privilege of traveling Fort Street. That's a joke because it is the bane of my existence on days when I have to do it, especially at 2:30-ish in the morning. It is full of construction. It is full of barrels. It is full of detours and arrows and lights that make it very difficult to navigate in that area.
Judge Malaika Ramsey Heath gave her ruling out loud at the end of a trial that lasted almost 2 hours. That one admission, hidden inside a long cross-examination, damaged the city's whole case more than almost anything else, because the prosecution's own witness had just agreed with the defense on the most important legal question in the whole trial. Let's talk about what's actually on the body camera, because the tone matters just as much as the law here. This is public court record, shown in court, and neither side disputed it. The officer tells Pletz, quote, "I love people like you who think that you're going to tell me the law." He calls him, according to the defense's closing statement, which the city did not challenge, a clown, and suggests he might be committing fraud, all before any ticket was even officially written. This is a 27-year veteran, specially trained on bicycle law, who couldn't answer basic legal questions about the very rule he was enforcing, while mocking a regular citizen for knowing that same rule correctly.
Rather than following a straight course of action, allowing him to avoid the obstacle that's here, weave back in, avoid the next obstacle that occurs in the next 2 feet, weave back in, weave back out. As a cyclist, I don't know that what a cyclist would determine is practicable in terms of staying close to the right-hand curve. Clearly, that sign was there with sandbags. And we can argue semantics about whether detour means closed or closed means detour. But as drivers, if we see a detour sign, we generally move. That's what a detour says. Even if it doesn't say closed, it means move somewhere else. You're detoured. And so we have a cyclist who saw a detour sign, according to him or his attorney, and moved. So then the question is, should he have moved back in, right? Or by not moving back in, was he obstructing traffic? And here's what was very telling to me. And I wrote it down in terms of the first video that was shown. Between 17 minutes and 5 seconds and 17 minutes and 7 seconds, when police cars were sitting in the lane, a large oil tanker truck went by, traveling the exact same direction. If that large oil tanker was not obstructed by numerous police cars and individuals in the roadway, it's difficult for me to understand how one cyclist obstructs traffic if a tanker can still get by? Because it did. It caught my attention because of what we're examining today. It was a huge truck. I invite you to go back and watch the video if you doubt what I'm saying. So somehow traffic is not obstructed by large vehicles, police cars, but is obstructed by a single cyclist. I don't think so. An officer, as it was phrased, kindly asking you to do something or giving you a friendly reminder to do something might be nice, but that doesn't turn a request into a lawful order simply because it's coming from an officer. It still has to have its basis in the law. Sergeant Terracinno testified under cross-examination that he was not familiar off the top of his head with the very statutes that are applicable to this case today. Absolutely, that was your testimony, officer. And if you don't want me to address you, then keep a poker face, because that was absolutely your testimony. We went over it many times where the answer was yes, no, or I don't know. The question was directly about the statutes and the content of the statutes. And the answer was, I don't know off the top of my head. And that's okay. I don't keep a book of statutes in my head either. And it's way easier to keep the general rule in your head than all of the exceptions. And here we have numerous exceptions that Mr. Pletz was relying upon. The biggest one being, I could not travel in the bike lane because there were obstructions in the bike lane. Whether we think it was enough room to maneuver around or his headlight should have lit it up for him. You know, I have a disease where I have vision issues. I don't know. I can't impute my ability to see to everyone else's. What we can see, though, is that there was an obstruction in the bike lane. And what was clear by the...
An order is not a law. That's twice now. And it's the same idea the judge used to take apart the second charge, too. Failure to show ID. Under Michigan Law 257.602, refusing a lawful order from an officer directing traffic is the crime. But the word lawful is not optional. The prosecution has to prove the order was actually legal, just like any other part of the crime. And if the order to enter the bike lane had no legal basis, which the court agreed it didn't because of the obstruction exception, then everything that came after, including the demand for ID, was never legally required in the first place. During the trial, the defense asked the officer directly, if Pletz had been riding legally, would he have had to show ID? The officer's own answer, on record, was no.
The end of the second video that was shown, as we all know Fort Street to be right now, is that it is full of obstructions everywhere. That barrel appeared to be very close to the bike lane at the end of the video. Now, Officer Tercinek saw it in person. Maybe it was further to the left than it appears to me. Maybe to Mr. Pletz, who was further back and not looking at a still photo of it as we are. He sees another obstruction in the bike lane. And so he's traveling the roadway until he gets past the obstructions that would cause him to, quite frankly, not maintain a single course, but be dodging in and out of traffic to avoid every obstacle in that bike lane, in that roadway. There is a practicality to the law. It's supposed to make sense. It's supposed to protect people and not endanger people. That's the only alternative, because we know that there's construction and obstructions all over that place. So the alternative is to say, well, Mr. Pletz should have just been dodging in and out on the bike lane when he could, off the bike lane when he couldn't, on the bike lane when he could, off the bike lane when he couldn't. At 2:30 in the morning, when there are possibly drunk drivers, all kinds of people could be on the street, although there didn't appear to be many that night. I don't know. I mean, I could say more. I think it'll just muddy the record. I don't think that, unfortunately, is something that we have to advise people, but we should not be saying to people, when an officer kindly asks you to do something or gives you a friendly reminder, you just do it or it's going to turn out bad for you. That's not the kind of place that we're supposed to live in. It's okay for people to know their rights. You don't even have to take a bar exam in every state in this country to be a lawyer. You don't have to go to law school in every state. Law is still done in some places through learning and apprenticeship. There are smart people who study and learn the law. There are quote unquote jailhouse lawyers that could go toe to toe with any of us in this courtroom today. I do not find that Mr. Pletz interfered with traffic. I do not find that Mr. Pletz disobeyed the lawful order of a police officer, just so it's clear. I believe that Mr. Pletz's actions fell within the exception of the statute, rendering the order for him to return to the bike lane unlawful. I do not believe that there is a violation here. My finding is not guilty on both counts. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, counsel. Thank you. Thank you, Sergeant.
All right. You guys have a good one. Thank you, Sergeant. You guys have a great day.
Okay, you too.
Judge Ramsey Heath found Mr. Pletz not guilty of disobeying a lawful order of a police officer and not responsible for interfering with traffic, concluding that no traffic was actually obstructed and that the order directing Mr. Pletz back into the bike lane was not lawful. This trial illustrates that a command does not become lawful or mandatory simply because it comes from a police officer. It must have a basis in the law. The same statutory framework that imposes duties on cyclists also grants them rights, including the right to leave the bike lane and the right edge of the roadway when obstructions make them unsafe to use. When an officer issues a directive that the law does not support, a person's refusal to comply with that directive is generally not a crime, and the burden remains on the prosecution to establish every element of an offense, including the lawfulness of the order said to have been disobeyed. As Judge Ramsey Heath emphasized in her ruling, knowing one's rights and asserting them is not the same as breaking the law. And this case is a reminder that the legitimacy of an order rests on its grounding in the law, rather than on the perceived authority of the person giving it.
An order is not a law. Third and final time. Because this isn't just a phrase we're repeating for effect. It's the actual legal principle a Michigan judge put into a real, binding court ruling. On the record, under oath, with the prosecutor's own witness agreeing with it from the witness stand. What this case really shows isn't just one bad night or one difficult officer. It's a pattern. What happens when someone in a position of power mistakes their own authority for the actual law? The assumption that just do what I say is the whole rule, and that quoting the real law back to them is treated like disrespect, instead of exactly what the law allows. Detroit's police department specifically trained this officer on bicycle traffic law. That training clearly skipped the exceptions written directly into Michigan law, the same exceptions a judge used to end this case in less than 2 hours of deliberation. If you want to check all of this yourself instead of just trusting us, the case is City of Detroit v. David Pletz.
She didn't try to please both sides. She found Pletz not guilty of disobeying an order and not responsible for blocking traffic. She stated clearly, for the record, that no traffic was actually blocked and that the order to get back in the bike lane was never legal to begin with. She went even further than most judges usually do. She said you don't need a law degree to know your rights, that even jailhouse lawyers, her own words, can go head-to-head with anyone in that courtroom when it comes to knowing the actual statute. And she said something every police department should sit with. Telling a citizen to just follow an order simply because it came from an officer with no legal basis behind it is not the kind of place we're supposed to live in.
36th District Court, trial held on May 21st, 2026, decided by Judge Malaika Ramsey Heath, and its public record, using People v. Luzinski as the controlling legal precedent. Read the transcript, watch the body camera footage yourself, and then tell us in the comments, if the officer's own testimony admitted that no ID was legally required, why did the department take this case all the way to a full trial instead of dropping it themselves? If this case frustrated you as much as it frustrated us while researching it, hit like. Share it with someone who still believes just comply and argue later is always the safest choice. Subscribe to Police Misconduct Case and turn on notifications, because we're not done showing you how often the badge and the actual law say two very different things.